So we continue with aggravating circumstances. I think I stopped at the third aggravating circumstance under Article 14. The fourth aggravating circumstance, that the act be committed with abuse of confidence or obvious ungratefulness. So under the fourth paragraph, there are two aggravating circumstances. We have obvious ungratefulness, and the other one is abuse of confidence. There is abuse of confidence as an aggravating circumstance when the following elements are present. First, that the offended party has trusted the offender, that the offender abused the said trust and confidence reposed on him by the said offended party. And lastly, the abuse of the said trust and confidence facilitated the commission of the crime. So it is necessary that the said abuse of the trust and confidence reposed on the offender by the offended party must have facilitated the commission of the crime, without which the crime would not have been committed. X was accommodated by A and B in their house. He has no place to live, and so A and B accommodated him, provided a room for him in their house, and allowed him to live there without pay. Since he used to be a good friend, and so now since he is nowhere to go, A and B accommodated X in the said place. One time, when everybody in the house was out, and it was only A, the wife, who was in the house, X went to the kitchen, and finding there the wife, X, by means of force and violence, had carnal knowledge of the said wife against the will of the wife. And so a case of rape was filed against X. In the information filed by the Office of the Public Prosecutor, it was alleged that the said act of rape was committed with the aggravating circumstances of dwelling and abuse of confidence. Are these aggravating circumstances attendant in the commission of the crime? Dwelling is not present as an aggravating circumstance. Although X was merely accommodated in the said dwelling, he used the place since the time of accommodation as one for his rest and comfort. Therefore, it cannot be said that he disrespected the dwelling of the said victim at the time of the commission of the crime because he too lives in the same dwelling. There is, however, abuse of confidence as an aggravating circumstance. The wife and the husband trusted the said abuse. Were it not for the said abuse of confidence, he would not have committed the crime of rape. The abuse of confidence facilitated the commission of the act of rape. Had he not been allowed to live there, the act of rape would not have been committed. Therefore, there is abuse of confidence in the commission of the crime. The fifth aggravating circumstance under Article 14, that the crime be committed in the palace of the chief executive, or in his presence, or in any place wherein public authorities discharge their duties, or in a place dedicated to religious functions. So in the fifth paragraph under Article 14, this refers to places. First, in the palace, that is in the Malacanang, in the presence of the chief executive, that is the president, in a place wherein public authorities discharge their duties, and also in a place dedicated to religious worship. This is considered as an aggravating circumstance because of the offender's lack of respect in these places. Therefore, in order for it to be considered as an aggravating circumstance, it is necessary that the offender deliberately sought these places in order to commit the crime. For it to be said that his intention was to disrespect this place in the commission of the crime. The X went to church. X was praying. After praying, on his way out, he saw at the end of the church, near the door, his longtime enemy. Upon seeing this longtime enemy, X went outside the church and then entered again the church, passing through the back door. After entering the back door, he stabbed the enemy repeatedly until the enemy died. the aggravating circumstance that a crime was committed in a place dedicated to religious worship is present. X, after getting out of the church, could have just waited for the enemy to come out. But what did he do? He went again inside the church, entering the church through the back door and stabbed the victim. Therefore, he deliberately went to the said place, a place dedicated to religious worship, in order to commit the crime. Therefore, it will be considered as an aggravating circumstance. Then we have the sixth aggravating circumstance, that the crime be committed in the night time or in an uninhabited place or by a band, whenever such circumstances may facilitate the commission of the crime. So in the sixth paragraph, there are three aggravating circumstances. We have nighttime, we have an uninhabited place, and the crime being committed by a band. Nighttime is considered as an aggravating circumstance when the offender deliberately sought the cover of darkness for any of the following purposes, either to facilitate the commission of the crime or to ensure or afford impunity. So he deliberately sought the darkness of the night, either to facilitate the commission of the crime. Because of the darkness of the night, he would be able to consummate the crime without any interference, or to conceal his identity because of the darkness of the night. No one would be able to recognize him. His identity would be concealed. If this is his purpose in seeking the cover of darkness, then nighttime will be considered as an aggravating circumstance. Note, however, that even if the offender deliberately sought the cover of darkness in the commission of the crime, if at the time of the commission of the crime, the scene was illuminated by any light, nighttime will no longer be considered as an aggravating circumstance. An uninhabited place is one which is far from houses, far from the town. But for it to be considered as an aggravating circumstance, the following are the elements. First, that in the place where the crime was committed, there was little or remote possibility for the victim to receive some help. And second, that the offender deliberately sought the said place in order to facilitate the commission of the crime. So, it is not the nearness or farness of the place from town and houses that will determine whether it is inhabited. It is the fact that if in the said place, there is little or remote possibility for the victim to receive some help. That is just the first element. It is necessary, based on the second element, that the offender deliberately sought the place in order to facilitate, to ensure the commission of the crime. The third aggravating circumstance in the sixth paragraph is if the crime is committed by a band. A crime is said to have been committed by a band when more than 3 armed malefactors shall have acted together in the commission of the crime. Therefore, there must be at least 4 armed malefactors who shall have acted together in the commission of the crime. Acted together, it means all of them participated in the commission of the crime. Therefore, they are conspirators in the commission of the crime, having acted together. These 3 aggravating circumstances, nighttime, uninhabited place, and by a band, can be considered separately or collectively if present in the commission of the crime. About 9 o'clock in the evening, the farmer got out of the field, and the said farmer was on his way home. While the said farmer was on his way home, it was rainy and there was no moon, and he would pass by all these houses in the said field, which wherein there are no longer any lights. It was already about 11 o'clock in the evening, and people turned off their houses because in the province, about that time, people are very fast asleep. So he was walking alone there when suddenly 5 men appeared in front of him. And then thereafter, these 5 men immediately stopped him. in the commission of the crime are the aggravating circumstances of an uninhabited place by a band and nighttime attendant. First, insofar as nighttime is concerned, the place was dark, it was raining, therefore 11 o'clock, therefore the offender obviously deliberately sought the cover of darkness to ensure the consummation of the crime. Is the place uninhabited? Although there were houses nearby, he would not be able to ask any help. There is remote possibility to ask for help. The houses, the people in the houses are already fast asleep. Lights were already turned off. The offender obviously sought the said place in order to ensure the commission of the crime. Is the crime committed by a band? Is band an aggravating circumstance? These are 5 armed men. Therefore, more than 3 armed malefactors, and all of them stabbed the victim. Therefore, they acted together in the commission of the crime. How many aggravating circumstances shall be considered? 3 separate and distinct aggravating circumstances shall be considered. There is nighttime, there is an uninhabited place, and there is a band. All 3 may be considered by the court in the imposition of the penalty. 7th aggravating circumstance, that a crime be committed on the occasion of a conflagration, shipwreck, earthquake, epidemic, or any other calamity or misfortune. If the crime is committed on the occasion of these calamities, this will be considered as a generic aggravating circumstance. But if the crime committed on the occasion of the calamities I mentioned would be that of killing a person, it is not merely a generic aggravating circumstance, it is a qualifying aggravating circumstance, because these are also included in the enumeration in Article 248 for the crime of murder, so as to qualify a killing to murder. The 8th aggravating circumstance, that a crime be committed with the aid of armed men or persons who ensure or afford impunity. With the aid of armed men, this armed man does not directly participate in the commission of the crime. This armed man merely aided the actual perpetrator in the commission of the crime. That is what makes with the aid of armed men different from by a band. In a band, all the armed malefactors must have acted together in the commission of the crime. In with the aid of armed men, these armed men need not actively participate in the commission of the crime. They merely aided the actual culprit. Therefore, they are mere accomplices in the commission of the crime. In the case of with the aid of armed men, the law requires that there must be at least 4 armed malefactors. In with the aid of armed, in case of by a band, there must be at least 4 armed malefactors. In with the aid of armed men, the law doesn't require any number of men, for as long as an armed man assisted, helped, supported the actual perpetrator in the commission of the crime. The 9th aggravating circumstance, that the accused is a recidivist. A recidivist is one who, at the time of his trial for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title of the code. The elements of recidivism and aggravating circumstance are first, that the offender is on trial for one crime. Second, that at the time of the said trial, he has been previously convicted by final judgment of another crime. Third element, that both the first and the second crime are embraced in the same title of the code. And lastly, that he is also convicted of the second crime that he committed. In case of recidivism, there must be at least 2 convictions. The first conviction is for the first crime that he has committed, and it must be a conviction by final judgment. The second conviction is for the new crime for which he is on trial, and thereafter the court found him guilty beyond reasonable doubt. It is on the second conviction wherein the judge shall consider recidivism as an aggravating circumstance. In case of recidivism, conviction by final judgment will suffice. The law doesn't require that the said convict had already served the sentence for the first crime. It suffices that he is convicted by final judgment. Under the third element, the law requires that both the first crime and the second crime must be under embraced in the same title of the revised penal code. So what if X killed Y, and thereafter X was prosecuted for the crime of homicide? After trial on the merits, X was found guilty beyond reasonable doubt. And X, the judgment became final and executory. X served out the sentence. After service of sentence, X is now out of jail. A few months upon release, X participated in a fight. In the course of the said fight, X seriously wounded his opponent. And so X is now on trial for the crime of serious physical injuries. After trial on the merits, the judge found him guilty beyond reasonable doubt of serious physical injuries. If you were the judge convicting the accused of serious physical injuries, would you consider recidivism as an aggravating circumstance in the imposition of penalty? Recidivism is an aggravating circumstance in the imposition of the penalty on X. All the elements of recidivism are present. First, he is on trial for one crime. He is on trial for serious physical injuries. Second, that at the time of the said trial, he has been previously convicted by final judgment of another crime. At the time of his trial for serious physical injuries, he has been previously convicted of the crime of homicide. Third element, both the first and the second crimes must be embraced in the same title of the code. They are both under Title 8, Crimes Against Persons. And last element, that he must be convicted of the new crime. The judge found him guilty beyond reasonable doubt of the crime of homicide. All the elements are present, therefore, the judge, in imposing the penalty for serious physical injuries, shall consider recidivism as an aggravating circumstance. But what if in the same problem, X was convicted by final judgment and has served sentence for homicide? Upon his release, he led a good life. After his traumatic experience for serving his sentence in homicide for many years in jail, upon his release, he now wanted to live a good life. However, 15 years thereafter, he engaged in a fight. And in the course of the said fight, he wounded his opponent seriously, causing the opponent to lose his eyesight. And so he was charged with serious physical injuries. After trial on the merits, the judge found him guilty beyond reasonable doubt of the crime of serious physical injuries. In imposing the penalty for serious physical injuries, the judge considered recidivism as an aggravating circumstance. But the counsel of this accused filed a motion for reconsideration, saying that the judge is incorrect in considering recidivism, considering that 15 years had already lapsed from the time of his release to the time of his commission of the crime of serious physical injuries. Is the argument of the counsel correct? The argument of the counsel is wrong. Recidivism does not prescribe. Therefore, no matter how long a period of time had elapsed between the first crime and the second crime, for as long as these crimes are embraced in the same title of the code, he is a recidivist. Time is immaterial. Recidivism does not prescribe. But what if in the same problem, X was charged with a crime of homicide? After trial on the merits, the judge found him guilty beyond reasonable doubt of homicide. Because of the presence of two privilege mitigating circumstances, the penalty imposed by the RTC judge on X has a maximum of 6 years. Since it is within the probationable penalty, Upon conviction by the court, X immediately applied for probation. Instead of appealing his case, conviction for homicide, he applied for probation. And his application for probation was granted by the court. And so, he is now out of the prison cell. Months later, he engaged in a fight. He seriously wounded his opponent. And so now he is on trial for the crime of serious physical injuries. After trial on the merits, the judge found him guilty beyond reasonable doubt of serious physical injuries. In imposing the penalty for serious physical injuries, can the judge consider recidivism? What about the fact that he applied for probation? Can he still be considered a recidivist? First element, he is on trial for one crime, present. Second element, he has been previously convicted by final judgment. And what is that? He has been previously convicted by final judgment of another crime. That is the crime of homicide. Would you consider, after conviction by the RTC judge, within the period for perfecting an appeal, X applied for probation and was granted? Is it a conviction by final judgment? It is a conviction by final judgment. The moment an accused, instead of appealing his case, applied for probation and the said probation was granted, it is akin to conviction by final judgment because he is amenable to the decision of the court. He is no longer questioning the conviction imposed on him by the court. It's just that he doesn't want to serve his sentence behind bars. Therefore, he is still convicted by final judgment, and the judge, in imposing the penalty for serious physical injuries, can consider recidivism as an aggravating circumstance. What if, in the same problem, he was convicted of the crime of homicide? It was a conviction by final judgment. He was serving his sentence at the New Bilibid prison. While he was serving his sentence at the New Bilibid prison, due to his political affiliations, he was granted pardon by the president. So, the moment this pardon was pleaded to the court that convicted him, he was now out of prison. Months later, he engaged in a fight. He seriously wounded his opponent, and so now he is on trial for the crime of serious physical injuries. After trial on the merits, the judge found him guilty beyond reasonable doubt of serious physical injuries. In imposing the penalty for the said crime, can the judge consider recidivism? The judge can consider recidivism. Reason is pardon does not erase the effects of the crime. Pardon only excuses the convict from the service of sentence, but it does not obliterate or erase the effects of the crime. Hence, he remains to be a convicted criminal. What if in the same problem, X killed a person, and so he was charged and convicted of the crime of homicide. X killed the said person for some political purposes, because X belonged to a political party, and he killed the said person for political purposes. And so, after having been convicted by final judgment, he is now serving his sentence. While he was serving his sentence, the President issued a proclamation for amnesty with the concurrence of Congress. Since the act of killing was done based on his testimony, due to political reasons, he applied for amnesty. And he was granted amnesty. So he's now out of the prison cell. Months later, he engaged in a fight. And so he seriously wounded his opponent, and he is now on trial and has been charged and has been convicted of serious physical injuries. In imposing the penalty for serious physical injuries, can the judge consider recidivism? The judge cannot consider recidivism. The judge cannot consider recidivism because amnesty erases, obliterates all the effects of the crime as if no crime has been committed. Therefore, since he was granted amnesty, In the first crime of homicide, homicide being done for political reasons, therefore it is as if no crime of homicide has been committed. Hence, recidivism could not be considered by the court as an aggravating circumstance in imposing the penalty for serious physical injuries. Defend aggravating circumstance that the offender has been previously punished for an offense to which the law attaches an equal or greater penalty, or for 2 or more crimes to which the law attaches lighter penalties. This is otherwise known as reiteration. The elements of reiteration are, first, that the offender is on trial for one crime. Second, at the time of the said trial, he has previously served sentence for an offense to which the law attaches an equal or greater penalty, or for 2 or more crimes to which the law attaches lighter penalties. And last element, that he is convicted of the new crime for which he is on trial. Based on the elements of reiteration, just like recidivism, it requires at least 2 convictions. The conviction is for the first crime, whereas that is the first conviction. The second conviction is for the second crime. It is on the second conviction or third conviction wherein the court shall consider reiteration as an aggravating circumstance. However, insofar as recidivism is concerned, a conviction by final judgment will suffice. But in case of reiteration, the law does not only require a conviction by final judgment. The law requires this person has already served sentence for the first crime that he has committed, or for the first and second crimes that he has committed. So it does not only require a conviction by final judgment, but there must already be service of sentence, insofar as the first or the first 2 crimes had been committed. Under the second element, there are 2 instances. The first instance, that he had served sentence for an offense to which the law attaches an equal or greater penalty. So if there are only 2 crimes committed, what the law requires is that the first crime for which the accused had served sentence must carry a penalty equal to or greater than that of the second crime. But if there are at least 3 crimes committed, the law requires that the first 2 crimes that he had served sentence must carry lighter penalties than that of the new crime. X was charged during an argument with his neighbor. X slapped the neighbor twice. The neighbor filed a case of slight physical injuries before the barangay. There was no amicable settlement, and so the neighbor filed a case before the fiscal's office within the 2 months prescriptive period. The fiscal found probable cause. The case was filed before the court. And so the judge, after trial on the merits, convicted X of the crime of slight physical injuries and imposed upon him the penalty of arresto menor 30 days. After service of sentence, 30 days, he was now out of prison. He was still mad at his neighbor, and so from prison, instead of proceeding to his house, he passed by the house of the neighbor. He was calling on the neighbor. He wanted to get even. He was calling on the neighbor to get out of the house. However, the neighbor didn't get out of the house, and he saw this fence of the neighbor newly built. And so what X did, he deliberately axed the fence of the neighbor, thereby causing damage on the fence of the neighbor. After damaging the fence, X left. The neighbor filed a case of malicious mischief against X. Based on the damage, the appropriate penalty is arresto mayor. No settlement. After trial on the merits, the judge found him guilty beyond reasonable doubt of malicious mischief. In imposing the penalty for this malicious mischief, can the judge consider reiteration as an aggravating circumstance? The judge cannot consider reiteration as an aggravating circumstance because the first crime, slight physical injuries, for which he had served sentence, carries lighter penalties than that of the second crime. When there are only two crimes, what the law requires is that the first crime must carry a penalty equal to or greater than that of the second crime. Therefore, in imposing the penalty for malicious mischief, the judge cannot consider reiteration as an aggravating circumstance. And so, the judge convicted him of malicious mischief. And the judge imposed upon him the penalty prescribed, arresto mayor, the judge imposed upon him 6 months imprisonment. Judgment became final and executory, he served the sentence. After service of sentence, he still mad at the neighbor, he went home. However, since he was still so mad at the neighbor and he wanted to get even in the neighbor, with the said neighbor, in his sworn statement, he alleged he made some malicious imputations, allegations against the said neighbor regarding the commission of a crime. The said statement being under oath and being all falsities, the neighbor got mad and filed a case of perjury against X. He is now on trial for the crime of perjury. After trial on the merits, the judge found him guilty beyond reasonable doubt. In imposing the penalty for perjury, can the judge consider reiteration as an aggravating circumstance? The judge can consider reiteration as an aggravating circumstance. X served 2 penalties. One, 30 days for slight physical injuries, and the other one is 6 months for arresto mayor. Both of these are lesser penalties than that prescribed by law for perjury, which is prison correctional. Therefore, under the second element, when there are 3 crimes committed, what the law requires is that the said offender shall have served sentence for 2 of these crimes, which must be lighter penalties. Therefore, the judge can consider reiteration in imposing the penalty for perjury, that is prison correctional. But what if in the same problem? So he was convicted of slight physical injuries. Thereafter, he was sentenced with 30 days imprisonment. He served the sentence. He again committed malicious mischief. After trial for malicious mischief, the judge found him guilty beyond reasonable doubt and imposed upon him the penalty of 6 months imprisonment. It is within the probationable penalty. And so X, instead of appealing his conviction for malicious mischief, within the period for perfecting an appeal, X filed an application for probation. And the judge considered and granted his application for probation. Upon grant of his application for probation, X is now out of prison. Once out of prison, mad at the neighbor, he stated in his own statement malicious allegations against the said neighbor for the commission of a crime. And so the neighbor filed a case against him for the crime of perjury. After trial on the merits, the judge found him guilty beyond reasonable doubt for the crime of perjury. In imposing the penalty for perjury, can the judge consider reiteration as an aggravating circumstance? The judge cannot consider reiteration as an aggravating circumstance. Reason is, insofar as the crime of malicious mischief is concerned, wherein he has been granted probation, he did not serve sentence. Probation is not equivalent to service of sentence. In fact, the effect of probation is to suspend the execution of the sentence. Therefore, since there is no service of sentence for the second crime, the offender cannot be considered in the imposition of the penalty. The judge cannot consider reiteration as an aggravating circumstance. The 11th aggravating circumstance, that the crime be committed in consideration of a price reward or